Hello friends, I welcome you all to lecture number 11 of criminal law basic concepts. This is lecture number 12 of criminal law basic concepts. This is Clat lecture series sponsored by Sri Jendra Rangzone. I am your mentor Shekhar Galot. So in the previous lecture, we were discussing the offense of rape. Okay. So now we are discussing another critical offshoot of the offense of rape. Okay. Sorry. Consent on pretext of promise of marriage. Now, consent on the pretext of marriage, there can be two types of consent on the pretext of marriage. Okay. When a man, woman enter into relationship on the basis that someday they will marry each other. Okay. Now, consent on the pretext of marriage. It means that sometimes two people come together, a man and a woman, they come together and they establish sexual relation. Okay, and the man says that I will marry you someday, and women takes that promise for real, and then she consents for sexual activity. This is the consent we are talking. Okay, that a woman have given consent to sexual intercourse to a man on the pretext of marriage, that someday he will marry me. There are two type of consent which can be given on the pretext of marriage. Okay, two types of consent can be given when a man says that I will marry you. Okay, let us discuss them. When a man and woman enter into a relationship on the basis that someday they will marry each other. Okay, man and woman enter into a relationship on the basis that someday they will marry each other. Many cases are there where people of metro cities, mostly working away from their homes, are forming unions and setting up their living relationships. Now, see, culture has changed, people are changing, and the world around us and India has changed a lot. Now, what is happening? A lot of youngsters are moving away from their home for the works, and they are going to different metros such as Delhi, Mumbai, Bangalore, Chennai, Hyderabad, Lucknow, etc. Okay, they are going to that places. Now they are there. They are forming alliances with different people of other sex. Okay, they are coming together. So now they are setting live-in relationships. Okay, we have seen a mushrooming rate of live-in relationship in metro cities. Okay, law says what law says. When a man promises to marry a woman on later date, okay, when a man says to women that someday, probably end of this year or next year, 2 year, 3 year, we will marry each other, and they set up sexual relations, then such consent would be deemed to have been taken by deception if law says such a consent would be deemed to be taken by deception if at the time of procuring such consent the man had no intention to marry and made a false promise. That when at the time when the consent was given on the pretext of marriage, when the man said that we'll marry each other, the man made a false promise and he had no intention to marry right from the beginning. Okay. However, provided if the promise initially was genuine, if he had made a genuine promise, and later on there were differences in couple and they fell apart. Okay, suppose they lived together for 1 to 2 years. Okay, initially the man actually wanted to marry her. But later on there were so many differences, they fell apart and man refused to marry. Man thought that our life will not be happy as a couple, we cannot marry. In such cases, that consent shall be treated as a valid consent and it shall not be considered a rape. If this is the case, that at the time of making this proposal of marriage, he made a genuine proposal, and on this genuine proposal, women allowed to have sex with him, then this consent will not be deemed to be a invalid consent. This consent will be a valid consent, and this will not be a case of rape. This will only be a case of couple falling apart. Usually, there are cases in which a man who is already married gets near another unmarried girl. Okay, usually what happens? How do we understand whether a consent was given when the promise of marriage was made? whether the promise of marriage was a false promise right from the beginning or not. How do we get to know that? Because promise is a state of mind. It happens with mind's person's brain. So how do we enter into someone's brain and know that whether when he made this particular promise he was making promise genuinely or he was making a promise fraudulently? Okay, how do we get to know that? Let us read. Usually, there are cases in which who is already married, a man who is already married, gets near another unmarried girl. Now, the man is already married. He gets near another unmarried girl and pretends. This man now pretends to be unmarried, divorcee, or widower. Okay, nowadays, people are making so many social accounts: Twitter, Tinder, Instagram, Facebook, and so on. They are putting their photos, their profile, and in their profile they claim themselves, their status, that I am unmarried or I am having this job, I am this and that. Okay, they are making attractive profiles. Okay, and he makes an attractive profile and gets near to any unmarried girl and pretends to be unmarried. He says that I am unmarried, or he says that I am divorced or my wife has died, I am a widow, or etc, and makes a marriage proposal for establishing the relationship. He makes a marriage proposal for establishing relationship with this girl and she gives a consent. In such cases, law shall presume that the consent was taken under deception. In such cases, law shall presume that this consent was not a valid consent and it was made under deception, it was made under cheating. As at the time of making the proposal for marriage, the man was already married and could not have contracted another marriage, hence, promise was deceptive. Now, this is how we come to know. When a married man makes a promise, he is not allowed to have a second marriage unless his religion permits him to do so. If his religion or his custom permits him to do so, then the promise will be a valid one. But if he belongs to a religion which allows only one marriage. Okay, one marriage means one marriage at a time, and he is already married, then that means he was making a false promise, and his promise was only to get the consent for sexual activity. Now, in this case, this consent will not be deemed a valid consent, and he will definitely be guilty of committing rape upon a woman. Or a woman who pretends to be unmarried. Now, this is a case where there is a woman who is now pretending to be unmarried, but she is actually a married one, and she pretends that she is unmarried, but she is married, and she enters into relationship with another man who is also married, another man who is also married and pretending to be unmarried. This man is also pretending to be unmarried. Woman, she is married, man, she is married to someone, but both are pretending to be unmarried and they both come close. And the man makes proposal for marriage that one day I will marry you. Okay, and she says okay, and with this proposal, she gives her consent to have sexual intercourse. Then this case will not be treated as a rape. In this case, it will not be treated as a rape, though when the man made the promise, he was unable to marry. But law says that when he made the proposal, the woman was already married and she knew that she could not marry. Okay, she could not marry, she could not have a second marriage when the first marriage is already subsisting. That means she should not have got swayed by marriage proposal, as she herself knew that she was incompetent to get married while her first marriage is still subsisting. Okay, so in these cases, even though the man made a false promise, but because even the lady was pretending to be unmarried, but she was actually married. So the court says when you are married, when you know that you cannot have a second marriage, when your first marriage is also going on, then you cannot say that I was swayed by the promise or I gave my consent because of this promise, because she herself know that she cannot marry. Okay. In the case of Dalip Singh versus State of Bihar, law said, court said, when I say law says, That means either the law or the court is saying both are equal. Such promise to marry would be punishable only if it is established that from very inception the man never really intended to marry. This is what Supreme Court is saying. If not, then he could not be liable for breach of promise. Okay. False promise of remarriage will not ipso facto make a person liable for rape. Okay, false promise of remarriage, like we are discussing. If someone makes a false promise of remarriage that I will divorce my wife and then I will marry you, this will not make you guilty of rape. Okay, plus women cannot be charged for rape, however, they can be charged for abetment of rape. This is all held in this case. Rao Harnaran Singh versus State of versus State. This is a citation. Now let us see what happened in this case and what this case says about consent. X, tenant of the accused. Accused means a person who's supposed to have committed the crime. Now this accused has committed the crime. X is his tenant. That means he is landlord and he is tenant. Okay. Forced his wife. X, tenant, forced his wife. X forced his wife to satisfy lust of the accused and his guest on the eve of entertainment party. Now X forced his wife that you have sexual intercourse with accused, that is landlord and his guest on the eve of entertainment party. She protested, but finally under pressure of her husband she surrendered. Now naturally a woman would protest, but he persisted, X persisted, and this case dates back to 1958. That time women did not have that much voice as they have today. Okay, so she submitted to the order of her husband. Okay, in that era it used to be order of the husband. Okay, in those dates, so she submitted to the order of her husband and she surrendered. Three accused raped her during night and she died almost immediately. Her shrieks were heard all over. Her shrieks were heard all over, even to the neighborhood. Okay, three accused raped her during the night and she died almost immediately. Now this case went to the court. Okay, and state said that these people are guilty of committing rape. Now this accused Rao Harnaran Singh, he said that we did not commit rape. Why you did not commit rape? He said that she had given consent. But finally, under the pressure, she surrendered. That she had given the consent and it was a consensual intercourse, it was a consensual sexual relation. When it was done by the consent, how could it be rape? That is what they said. Now see what court says. Court says that there is difference between consent and submission. There is difference between consent and submission. Mere act of helpless resignation due to irresistible compulsion, passive giving in, is not equal to consent. It says mere act of helpless resignation. Someone cannot do anything, someone has just submitted. Okay, they are helpless. They have no speech at all. So you are just committing rape. So this cannot be taken as a consent. This is submission. Submission is different from consent. Passive giving in, meekly giving in to your demands, is submission, not consent. A's husband is in jail. Police officer beats him regularly. A visits police officer and pleads not to beat husband. Not to beat husband. Okay. Now, see these two cases. A is the lady whose husband is in jail and a police officer beats him regularly. Okay, police officer beats her husband regularly. A visits police officer and pleads not to beat husband. She goes to the police officer and pleads him that please not do not beat my husband daily. What has he committed? Whatever crime he has committed, he is being put behind the jail. Why are you beating him now? Officer asks her for sexual favors. Officer says that I'll keep on mercilessly beating your husband till the time you do not say yes. And then she agrees. Okay. Or A, who's a very poor lady. Her son is ill. She has no money for the treatment. She goes to the money lender to take money. He says, I will give you money only if you give me sexual favors, and she agrees. Now, in these cases, in both cases, if you see, she agrees. That means she has consented to the sexual intercourse. Here, she has also consented to the sexual intercourse. But the law says that this consent is not a valid consent. One is not allowed to exploit someone's helpless situation and call it a consent. This is not the consent which law envisages. The court says you cannot treat these cases as a valid consent. You cannot exploit someone's poverty or someone's helplessness in saving her husband, and then you ask her for sexual favor, and because of her no choice she says yes, and then you say I have not raped her. She agreed to it. It was a consensual act. No, this is not a consent. Law says this is called submission. Someone is submitting to your will because she is helpless or she is poor. She has no option. You cannot take it as a consent. This is not equal to consent. Consent requires voluntary participation after having exercised free choice. There's a difference between resistance and assent. Okay, there's a difference between resistance and consent. You cannot treat no resistance as automatically a consent. Okay, consent requires voluntary participation. Court further said consent in order to relieve an act of criminal character must be an act of reason. Consent must be an act of reason where you apply your mind, you think over it, accompanied with deliberation after weighing both good and evil. Okay, you weigh down what is good and what is evil with power to withdraw the assent according to one's will and pleasure. That someone should have power to withdraw her consent. In these cases, they do not have power to withdraw. This wife did not have power to withdraw her consent. She may have made her consent. Let us assume that she made her consent, but did she have any power to refuse? No, she did not have any power to refuse. Do these lady have any power to refuse? No, they do not have any power to refuse. If such sexual intercourse is allowed to happen, it will lead to an immoral society, and it is going to make the position of women extremely weak. We cannot do that. India is zero tolerance for sexual offenses. Okay. So this is what law has to say about consent which is taken on the pretext of marriage, and this is what law has to say about consent which is different from submission. Now let us go for notion of obscenity under IPC, because we are doing this chapter is titled as obscenity and sexual offenses. Now we are done with the sexual offenses. Okay. Now let us proceed to notion of obscenity under IPC. What is obscenity? Let us go to obscenity. Obscenity is not defined in the Indian Penal Code. Definitely, defining obscenity is a very difficult task. Like we discussed when we began the chapter of obscenity, obscenity is a evolving term. It evolves with the society. You cannot define it. Defining something means you are putting something in a straight jacket manner. You cannot put something like obscenity in a straight jacket manner. Why? Because obscenity depends a lot upon the society and societal moods and social codes and social morals. They keep on changing every time. So you cannot define obscenity You cannot define obscenity, and it is very difficult to define it. Okay, so that is why it is rightly not defined in the Indian Penal Code. There have been certain tests which the law, but now if there is some case in which obscenity is pleaded, someone says that this there has been an act of obscenity. Okay, now how do we understand that obscenity exists in something or not? Okay, there have been certain tests which law has followed time and again to determine whether certain activity is obscene or not. Now, law says that there are certain tests which will determine which court will use to understand whether something is obscene or not. Okay, these are those tests: Hickling test plus community standard test. So let us see what Hicklin test says. Hicklin test is the test named after the person Hicklin who devised this test. The Hicklin test of obscenity examined whether the tendency of material is depraved and corrupt, whether the tendency of material is to deprave and corrupt minds that are open to immoral influences and into whose hands the material may fall. Okay, Hicklin test says whether the tendency of material is to deprave and corrupt minds that are open to immoral influence. First of all, it says minds that are open to immoral influences. What are those minds which are open to immoral influences? Let us say children, they are not mature enough, or let us say illiterates, okay, illiterate people, or uh, people not people not thoroughly mature. Now, why do I say that these people are prone to immoral influences? Because children, definitely, due to their tender age, small age, okay, they cannot appreciate something, and they are easily offended, or they are easily attracted to obscene things in such age, adolescent age. Okay, illiterates, suppose there's a book has some material, something written into it, and some pages are also there. Pages are obscene, book is saying something else, but pages have some pictures. Now one person is illiterate, definitely he cannot read a book, but what he'll do, he'll ultimately open the pages, he'll view the pictures. Okay, in this case he cannot understand what the magazine is all about, what the book is all about. Book may be drawing a very beautiful comparison between the photo and the story, but they cannot read the story, they can only watch the pages. So if pages are that vulgar, that if an illiterate people takes the book and sees the picture, he'll think of sexual desires. People not thoroughly mature, people who are not thoroughly mature, anyhow this bracket is very difficult to identify. These two brackets can be identified. Okay, so Hicklin test says obscenity examined whether the tendency of material is to deprave and corrupt minds that are open to immoral influences, and into whose hands the material may fall. Now suppose there is a Harry Potter like book. There's a picture, there's a Harry Potter like book, fiction book. It contains nude pictures, sexual sentences. In whose hands will this book ultimately go? Definitely, usually, children. This book will go in the hands of the children. Are they mature enough to watch nude pictures and to read sexual sentences? No. Okay, so Eklund test says if you have a book which is of such nature that it can go to children who are understood to be people who can easily be influenced, who can have immoral influence, and the book is going to in their hands. Okay, then definitely the work is going to be obscene. Then the next is this test allowed the material to be judged on the basis of isolated parts of the work by their influence on the most susceptible readers. This test allows you to apply the book to judge the book on the basis of isolated parts. Isolated parts means individual parts. You just see the part and you judge the part. You do not compare the part with the whole book. Let us see what this test says. Hickling test says. Now there's a book, it contains 10 chapters. 9 chapters are sound in nature, and one chapter is having great details about sexual activity and pictures. It has sexual pictures, nude pictures as well. Okay, now if we see the book as overall, if we see the book as a whole, the book has 10 chapters, 9 chapters are good. So that means overall, if we evaluate the book will be ultimately good. Why? Because only one chapter is wrong. But the Hicklin test say you can even take this one chapter out and see whether this one chapter alone has something bad or not. Okay, or you can take out certain lyrics from a song. Okay, the whole song may not be bad, but some certain lyrics, some language in the song, particular language is bad. Take out certain lyrics from a song. Watch certain isolated scenes of a video or a serial and all. Okay, that means you can watch things in isolated manner. That is how censor board works, isn't it? That is how censor board sometimes say you remove this scene, you remove this word, you remove this page, because they are watching the thing in the isolated manner. This is the Hicklin test says that if to a judge a case is brought that something is having a obscene content, how do judge understand or come to a conclusion whether the content is obscene or not? How will a judge come to this conclusion that whether this particular thing which is being told as obscene is actually obscene or not? Okay, the judge will apply this Hicklin test. Then the another test is community standard test. Community standard test. The community standard test of obscenity examined while viewing the said picture in the background of which it was shown, and the message it conveyed to the public and world at large. Okay, the community standard test is it says that we will apply we'll watch the situation whole scenario and then we will judge according to it. Now let us see. Let us take an example. There is an advertisement. Okay, there's an advertisement in a magazine which seeks to promote breastfeeding, benefits of mother's milk, and that society must accept breastfeeding as normal activity, etc. Now they are giving this message. Okay, but now what they have taken a picture on this. There's a picture in which a lady is standing and she is having a child in her hand and she is feeding the child and her breast is uncovered, her breast is visible. Now someone goes and says that see this is a nude picture, she is semi nude, her breast is visible, so this is an obscene picture, this should be removed. Okay, or this should be confiscated. There should be a case against the person who has clicked this picture or who has published this material. Now the law says we'll view it, the said picture in the background of which it was shown, the message it conveyed. Now, what this is at all, they are trying to promote breastfeeding. They are trying to tell the benefits of the mother's milk, and they are saying that society must accept breastfeeding as normal activity. It is seen that a woman who's carrying a child, suppose she is in a bus, she finds it difficult to breastfeed the child is hungry, he has his own time, she has his own time, she is in metro, she finds it inconvenient to feed. They are saying that we should make it a rule that if a lady is there with a child and if she wishes to breastfeed, we should give her some space. Suppose a man is sitting next to a lady and she wants to breastfeed, man should definitely get up and let some lady sit with him. Okay, something like this. We are promoting, they are trying to promote a healthy culture. So we cannot definitely call such a picture as an obscene picture, isn't it? This is what community standard test says, that what you are trying to tell to the community by this particular thing. Now let's discuss these cases where Supreme Court has applied Hicklin test in coming to conclusion whether there is some obscenity or not. The Supreme Court held that photograph cannot per se be called obscene unless it has a tendency to arouse the Supreme Court said that a photograph cannot per se be called obscene unless it has the tendency to arouse feeling or revealing an overt sexual desire. Now, Supreme Court is somehow trying to define what is obscene, somehow trying to determine what thing we can call obscene. Supreme Court says that something which is having tendency to arouse feeling, sexual feeling, or revealing an overt sexual desire. Okay, you watch something and you think of sex. That is obscene, otherwise not. Since the cover story of magazine carried the title Posing Nude, Dropping Harassment, Battling Racism in Germany. Now these are the facts of the cases. What is the case? There's a magazine which carries the title Posing Nude, Dropping of Harassment, Battling Racism in Germany. It was clear that motive of such a photograph was against apartheid. Apartheid is racism or discrimination on basis of color. Okay, so this is a magazine of Germany. Okay, so German people usually are white in color, so definitely they are racist. They are having some discrimination against those people who are colored, who do not have fair skin. Okay, who are colored people. It was clear that the motive of such a photograph was apartheid. Apartheid means discriminating against a person who is black or brown in color. It also held that since the breasts of Barbara Fultus were fully covered with the arm of Boris Becker, the photograph was semi-nude and had no tendency to deprave or corrupt the minds of the people in whose hands the magazine, Sports World or Anand Bazar Patrika would fall. Now Supreme Court said applied Hicklin test and see so that the sports magazine would definitely go to mature people's hands. Okay, and plus if mature people would see the photograph, there is no nude, everything is covered here. Okay, then people will not have sexual feelings just because of this photo. The court held that photographs was not obscene within the meaning of section 290 of IPC 292. It did not excite sexual passion or tended to deprave or corrupt the minds of people in whose hands the magazine or newspaper may have fallen. Now, this is Hicklin test. Further, what law says? Further, the photograph in the article in which it appeared conveys the message of racial equality. Now, this article photo is conveying the message of racial equality. It has two people. One is Barbara Fultus, another is Boris Becker. Now, they are interracial. One is black, one is white. They are marrying, and they are showing that there can be marriage in the intercolor people as well. We should not believe in racial discrimination. the message of racial equality and promoted love and marriage between persons of different racial backgrounds. According to the court, found no offense. Now, court is saying there's no offense at all. They are giving a good message to the society. So, in this case, in this sentence, Hicklin test is applied. Here, they are applying the community standard test as well. That they are actually giving a good message. Community standard test was applied. Rahul Mukherjee versus State and City of Delhi. Now, this is a case of Delhi. Police found a couple sitting and exchanging kisses near court. Now there's a couple sitting and exchanging kisses near the court. You may have seen these in foreign countries. People are behaving like this and that, but India doesn't believe in such things. India does not allow such. Okay. Anyhow, let us see. Waiting for registration of their marriage. The officer filed a complaint under Section 294 of IPC for obscene acts in public as it was annoying for the passerby. Court asked why would a married couple exchanging kisses in public will amount to obscenity and trigger the coercive process of law. Hence, it does not amount to obscenity under Section 294 of IPC. Court said that society has now grown up. We are now mature. Okay, we are now mature. Court said there is nothing wrong. Court said that there is nothing wrong with this. Kissing someone simply will not arouse some sexual activity, sexual feeling in other people. Okay, on contrary, people may feel ill about them. Okay, so this is what court says that this is not the kind of society we are. We are now a society which is updated one. We cannot punish simply someone because someone is kissing someone, someone is wearing a short dress, someone is enjoying her drinks or like that. Okay, just because some girl is wearing a particular dress, it's 10 o'clock, or she is enjoying her liquor or something like this, she also has a right like a man has. Okay, we have grown up as a society, so these acts will not constitute an offense which will call them an obscene act. Okay. Okay, now in the next lecture, we'll begin with the offenses of marriage. We'll close this lecture here. We are done with the sexual offenses. We are done with another part of the criminal law basic concepts which deal with the sexual offenses, that is outraging modesty of women and rape, and as well as what is obscenity. Okay, and how to identify obscene acts.